Good morning and welcome to the January 24th, 2019 Zoning Board of Adjustment meeting. If any member of the audience wishes to speak to an item on the agenda, there are speaker request forms to the left of the dais. Please fill out the request with the agenda number of the item you wish to speak to and hand it to the secretary. At this time, we would also like to ask that if any member of the audience has a cell phone or other electronic device, that you either turn it off or turn the ringer to silent. If you need to take a call, please step out to the hallway so the meeting is not disrupted. The public hearing on item number 1, the approval of the January 10th, 2019 Zoning Board of Adjustment meeting minutes, is open. Rachel made the motion to approve these meeting minutes and Mike Kwasny seconded that motion. Any discussion on the motion? All those in favor, please say aye. Aye. Opposed? Motion carries. Item number 2.
Thank you, Mr. Chair. Item number 2 is a variance to the zoning ordinance to reduce the parking requirement from 16 parking spaces to 9 parking spaces for a use known as midwifery. This use would include, per their operational plan, 2 midwives on the property, maximum at any one time, with 4 patients, a front desk employee, and 1 nurse. They've indicated that with that they would actually need only a total of 6, but they are proposing to construct 9. So with that, I'll show you some slides. An aerial of the 2 properties. They're both owned by the same individuals. The one on the left is zoned general commercial. It is the previous location of Loftus Dental that has since relocated out to Catherine Boulevard. That building is currently vacant. And then the property to the east is zoned office commercial. There's a single-family residence and a garage on that property. The future land use plan shows the property as urban neighborhood, even though this is a mix of residential and commercial uses along this section of Jackson Boulevard. Jackson Boulevard is an arterial street, which does support the commercial uses that do exist along that street today. This is a faded out site plan. So when we look at it, there is parking that's being proposed within this area. So we're going to have 4 spaces here and 5 spaces over here with drainage in the middle. These would access this way. These would come in off of Jackson Boulevard and access. I'm going to show you an aerial, or excuse me, a picture of the property and go into a little history as to why we're needing to do this. That's just showing you the area in the middle that will be used for drainage. You'll see some retaining around that parking because of elevation. Those show the drainage areas and contours. So that is the previous Loftus Dental building on the left and the existing residence on the right. When we look a little farther to the top of the screen, you'll see a brown office commercial building. At one time, the Loftus property and that property were owned by the same individuals. They sold the brown office building, and when they did so as a part of that sale, the parking in front of the Loftus building was sold with it. So since the building became vacant, we've been working with the property owner to see how they could reuse that building, knowing that they cannot count the parking in front of their facility towards their parking requirement. And what was determined is that since office commercial allows parking lots, they could put it on the adjacent property. The single-family residence is currently there. When this variance came in, staff struggled with it from the onset because we're going to have a commercial parking lot in front of a residence. However, they own both of those properties. They could come in today and get a building permit to build that parking lot in front of that residence. And they would have to meet all of the building code and design criteria. So the only question before you today is whether or not the 9 parking spaces that are being proposed for the midwifery use is sufficient for that use. Looking at the operational plan that the applicants have brought in, staff has determined that it does appear that the 9 spaces are sufficient. When we look at the criteria for granting a variance, we look at whether or not reasonable use of that property could be achieved if this variance was denied. Because of the purchase agreement years ago with the property to the west, they don't have any parking on that commercial lot with the Loftus Dental site. So it does meet the requirement or the criteria that without a variance, reasonable use of the property could not be achieved. In addition, granting the reduction from 16 required spaces per the zoning ordinance down to 9 is a minimum adjustment to ensure that they've got sufficient parking. So this is unique, noting that they could create the parking lot in front of the single-family residence today based on the operational plan, and this being a minimum adjustment to ensure reasonable use of the property. Staff is recommending that the variance be approved with several stipulations that do require some adjustments to the approach, the pavement, working with DOT to get a right-of-way permit, and noting that this variance is specific to this operational plan for this use. Any expansion of this use or change in use would require a new variance. So with that, we are recommending that it be approved.
Thank you, Vicki. Are there any, Mike, I see you have a question.
Vicki, did I read that there was something about a lease for parking? I thought there was something in the, you had put in the stipulations. So that is something that would go if it should resell, or how would you write that lease? Or
Mr. Chair?
Yep.
So the reason for that is those are 2 separate properties. Even though today they're owned by the same individual, one could be sold today to someone else. So we want to make sure that the parking that's on the office commercial property is always reserved for the use on the general commercial property. And we see this throughout the city on many properties. And we do that through a parking agreement or lease that says parking on Lot B is reserved for the uses established on Lot A, as an example.
Rachel?
Okay, so I understand that the building owners also own the residential property. And I agree that it's not going to be injurious to the public. You know, it's the lowest minimum adjustment, you know, required for reasonable use. So I'm not against this, but I'm curious, can they rent out or sell that residential property as is? Are they limiting access to that property, or how does that work?
They do currently have the residents rented out. So if we just kind of go back to, John went out and took some good photos of this. So that access that currently serves the garage will be the same access that serves the parking that's to the left of that driveway. So there will always be a clear access aisle where the renter of the residence can access his parking in the garage, and then the customers of the commercial use can then pull in and park at a 90-degree angle using that same driveway as an access aisle.
Okay, and I think normally I would be concerned about the minimum, you know, how few parking spaces are, but I understand that by design, midwifery is a low volume, you know, sort of practice, and I'm really excited. You know, I probably shouldn't say this, but I'm really excited that we're getting a clinic here. So thank you.
Are there any other questions on this item? If not, look for a motion.
Use your mics, please.
Sorry. I move to approve with staff stipulations on the basis that it's the minimum adjustment needed for reasonable use.
Thank you, Rachel. Is there a second?
Second.
Mike Quasny seconded that. Any, with the stipulations, yes. Any discussion on the motion? All those in favor, please say aye. Aye. Opposed? Motion carries. Item number 3.
Thank you. Item number 3 is a variance request to allow multiple setback reductions and reduced lot sizes for the property located on the corner of Chambers Street and Twin Elms Drive. The applicant is proposing to subdivide the existing property into 3 lots and submitted a preliminary subdivision plan application this last November. One of the stipulations of approval in that plan was that the applicant seek these variances for setbacks on the existing structures and reduced lot sizes on the property. Let's try that again. Just 1 second. We may have lost power on the computer. Is it plugged in? Nope. Oh, computer's on. Just 1 moment.
I'm not sure we should laugh, but I do take a little solace knowing that the same thing that happens to me in private life happens in public life as well.
Yep. Just 1 moment. As part of this request, the applicant is seeking multiple variances on existing structures on the property. And when we get into the slide, I'll go into those in a little more detail, but it'll probably be helpful to have the site plan up as we're looking at that. I'll do it. Okay. There we go. The subject property is zoned medium-density residential district and is approximately 0.52 acres in size. This is an aerial overview of the property showing the existing parcel, and you'll note that it is under one parcel ID at the moment, but within that parcel there are portions of 3 separate lots. On those lots currently there's a single-family home here, an existing duplex here, and then multiple accessory structures throughout the eastern portion of the lot. And it's the applicant's intent to be able to create and subdivide this existing lot to create a 3rd proposed lot on the east end of the existing parcel to be able to add a small duplex onto that side of the property. Future land use for the plan identifies it as urban neighborhood, and on the city's major street plan, both Chambers Street and Twin Elms Drive are identified as local streets. And this is an overview of the site plan that the applicant submitted, showing all the existing structures on the property and the proposed setback reductions. So you'll notice on the property, in order to create this proposed Lot 3AR, the applicant is intending to reconfigure the interior lot lines to be able to develop Lot 1AR, Lot 2AR, and Lot 3AR separately. In order to provide access to proposed Lot 3AR, the applicant is seeking multiple setback requests. Specifically, on Lot 1AR, the applicant is intending to allow a reduction in the front yard setback for a single-family home of 5.5 feet in lieu of 20 feet, a reduction in the front yard setback for an accessory structure here of 6 feet in lieu of 35 feet, a reduction in the side yard setback for the accessory structure of 1.7 feet in lieu of 8 feet here, a reduction in the rear yard setback for the single-family home of 7.53 feet in lieu of 25 feet required here, and a reduction in the minimum lot size required of 5,294.8 square feet in lieu of the 6,500 square feet required for a single-family home. On Lot 2AR, the applicant is requesting a variance to allow a lot size of 5,888.7 square feet in lieu of the 8,000 square feet that are required for a duplex. And on Lot 3AR, the applicant is seeking a variance to allow a setback reduction for an accessory structure of 4.76 feet in lieu of 35 feet required, a front yard setback reduction of 28 feet in lieu of 35 feet required for another accessory structure here, and a reduction in the required side yard of 1.7 feet in lieu of the 8 feet required for an accessory structure. The applicant's intent with these variances is to be able to preserve the existing structures on the lot and reconfigure Lot 3AR so that they can squeeze a small duplex onto this portion of Lot 3AR. The applicant's intent is to be able to redevelop the block in line with the density standards that are already present in the neighborhood. But in order to do that, if you notice in the aerial photo, down on the southeast portion of the property, this accessory structure and lot was occupied as a single lot. They could not develop these properties individually and sell those lots off, which would create an inaccessible lot for the accessory structure. So the intent with this variance request for the setback reductions and lot size reductions is to allow access to the proposed Lot 3AR so that each of these properties can be developed individually. And if you'll take note that the existing property between the three proposed lots is approximately 22,500 square feet. Based on Rapid City Municipal Code today, the density that would be appropriate, or the lot size that would be appropriate for one single-family home and two duplexes would be approximately 22,500 square feet. So the density that the applicant is proposing for the entire development is in compliance with Rapid City Municipal Code standards today. It's only the lot configurations that are necessary to provide access to Lot 3AR that make these structures non-conforming. So with that said, staff does recommend approval of the variance request as noted, with one stipulation in the staff report, and that is that the applicant coordinate with the Rapid City Fire Department to provide fire sprinkler protection on the existing and proposed residential structures on the lot due to the increased density in the area and the proximity of the existing structures on the property. I was able to visit the site and take a few site photos. This is the view from the northwest looking to the southeast. This is showing the existing single-family home, the existing duplex, and some of the accessory structures back here to the east. This is a view to the south along Twin Elms Drive, again showing that existing duplex. And this is a view along Chambers Street looking west. So you'll note what the existing setbacks are for that single-family home and some of the accessory structures here in the foreground. This is a view of two of the accessory structures right now that are requesting front yard setback reductions and reductions in their side yard setback of 1.7 feet in lieu of 8 feet required. This is another view of the single-family home, again showing the front yard that exists today, and a view of the rear yard setback that's existing for the single-family residence, and they're requesting a reduction of 7.53 feet in lieu of the 25 feet required for a rear yard setback for a single-family home. And with that, staff would recommend approval of the variances with stipulations as noted in the project report, citing criteria number 2 and number 4 that the application is in the general spirit and intent of the ordinance. Staff is available for questions at this time if you have any. I believe the applicant's consultant is also in the audience too.
Thanks, John. I do have a couple speaker requests on this, if there's
Chair?
questions. Yeah, Vicki.
Yeah, before you guys ask your questions, if we could get John to put the aerial up that you used to show the lots and go through the variances. So just a point of clarification, John mentioned that you have previously seen a preliminary subdivision plan to create these 3 lots, and one of the stipulations was that they needed to address all of these issues for the zoning. As a part of that plat, they also are required to dedicate right-of-way along the 2 adjacent streets. So whenever you're replatting, if your setbacks are legal nonconforming today, the only setbacks you have to meet are where the new lot lines are. Well, when they dedicate that additional right-of-way, those front setbacks change. Hence the reason why you've got all the variances to reduce those setbacks for the accessory structures and the single-family home. Between Lot 1AR and 3AR, there are the two sheds that John went out and took pictures of. The intent is then to draw a lot line between those sheds in order to determine where the accessory uses would be to those primary residential structures. As a result, the lot sizes then got locked down. So there is a public benefit to the dedication of the right-of-way. There are existing structures that create some of these other setback issues that are the unique situation in order to support these variances. I just wanted to make that clarification if it is your intent to see these three sites renovated, similar to the three farther west. About 2 years ago, we brought you a similar preliminary subdivision plan and multiple variances for 3 single-family homes. They were purchased, remodeled. The street was improved with curb, gutter, sidewalk, etc. Similarly, that will happen now, extending down to the corner. But in doing so, I wanted to clarify what criteria you could use in order to support these, if that is your intent.
Thank you, Vicki. I don't have any questions up right now, so I'll go to Kathy, and I got to be honest, I can't quite catch your last name, but if you'd like to come up and speak, please do. And once you're up, please state your name and address, just so we have it for our records.
My name is Kathy Munch. I live on 2001 Twin Elms Drive. So I live right across from the greenhouse. So in other words, my concerns are, after having we had purchased the house about a year and a few months ago. So now we have lived in this area, and now we're backing out and we're backing down onto the street to get out of our driveway. And I know that most households have 2 cars. So consequently, whenever there is a car parked on the street, it is very treacherous on how you back out. That's my first concern, is how many cars are you going to allow to be parked in the area, going through the area. There is a lot, if you look at how many houses are in that area, and now you take that times 2, and then how many, if there's a duplex, okay, now you got 2 families instead of 1 family. Now you got, instead of 2 cars, now you got 4 more cars. So I want you to take that into consideration, and then also the height. I would be against anything going higher than a 1-story. That is my concerns, and I would be upset if all of those things are not taken into effect.
Thank you. I also have a speaker request form from Kevin Andreessen, or Anderson. Not sure which time I got it right.
Good morning. My name is Kevin Andreessen. I'm actually representing the development. I'm the person who intends to purchase these properties. This is basically a phase 2 project, as Vicki mentioned, of re-improving this, substantially improving this block. And what our intention would be is to come in and do similar improvements that have been already done, and we've displayed in that first part. I'm here to answer a couple questions, and then I had one request to the staff recommendation. My request to the recommendation would be to consider not having the fire sprinkler requirement on the existing structures. It's not economically feasible from a redevelopment standpoint for us to consider that. I would be very open to putting that into any new structure that we would put up, but I would like to ask for your consideration on the existing ones. We did that on the first phase where the sprinkler requirement wasn't requested. And then to address the questions that have already been asked here in terms of parking, the duplex structure that we put up would have at a minimum 1 car, if not possibly a 2-car garage. We're working through design on that at this point. We wanted to see how this netted out in terms of lot width and what sort of structure we can design, and that'll impact the height, but our intention would be to not exceed 2 stories. We do have a design that could be a 1-story. But I would have to look at how that fits on the building footprint as a result of this replat. So that would be to address the questions that were previously asked.
Thank you. Are there any other questions for Kevin while he's up here? Kurt?
Looking at the site plan that was put together, that, I got to get it up here, Lot 3AR, there's 4 garages on that piece of property that's shown all to remain. Now, is your intention to tear those down when you build a duplex, or are you going to try to squeeze even more in there?
No, our intention, if we move forward with the duplex, would be to tear the front 3 structures that you see up there. I'm not sure how to write on this thing, but basically the one closest to Chambers Street, the one kind of in the middle of 3AR, and then the one immediately in front of the larger structure in the back I would propose to pull down if we move forward with the duplex construction.
Okay, because there are, percentages of building that you can put on, area that you can put on, and I'm wondering if you're going to be coming back for another variance to pack even more in there and get less percentage of open space.
Yep. Those would be the 3.
Those ones go away, okay?
And I don't think, Kyle, that we've done a calculation of what our coverage would look at if we pulled those out, but
This is a neighborhood where things are really packed in there tightly. I mean, we've had other developments looked at in this area that, that they are tough to meet the requirements, and, the setbacks don't bother me so much, but the packing of lots in there, or not lots, but of buildings and not meeting the minimum requirements for open space within those lots does bother me. So do you have any idea how many square feet of a footprint you're planning there?
to make the project financially feasible, we need 2 units, and based on market rates, we would need probably approximately 1,100 to 1,300 square feet per living unit. And that's where we kind of get into that discussion of whether we go, with a single story with a finished basement under it, or if we go with like a 2-story and a garage stack in that. So we've got 2 concepts we're currently working on, but we haven't finalized that for this lot at this point.
Okay. Well, I know if, this will probably get approved, but, if you come back, in 6 months or whatever, and then you're looking for a lesser open space on that property, you're going to have a hard time convincing me to approve that. So anyway, that's my comments, and thank you.
Okay, thank you.
Karen?
Thank you, Mr. Chair. Following up on Kurt's comments, the idea that you had the lot split between the 2 buildings and now you're taking one down, if you moved that lot line over a little bit and had the 2 current structures, you would get 2 current lots that are there, your lot 1A and 2A, you'd have more square feet for those 2 lots. But in doing that, is that going to cause 3AR to not have enough open space? And that's following up the same thing that he did. I'm just curious to know why the lot line is there and not moved over.
Well, at this phase in the project, our plan is basically to clean up the property and get them on basically separate properties. I have not fully committed to building that duplex on lot 3AR, so I needed to basically understand kind of where we would come out in the replat process, and that would drive, kind of what I ultimately design, and if that's financially feasible, to move forward on that 3rd lot.
So if you're replatting that, are you saying that there's a possibility that 3AR might not have that line there, it could be moved over?
I think this is the most practical way to subdivide it as it stands today without making significant changes to the properties. And, you know, as we move forward, we'll consider the coverages, you know, as been requested. But, so I guess I don't track with your question completely.
Okay, what I'm saying is, you don't foresee changing that lot line for 3AR by moving it farther to the, whatever direction that is, to the right on your screen, so that 1AR and 2AR have more coverage?
No,
for the-
I would not intend to do that. We're going to need that much building footprint to fit a duplex onto. And that's been our challenge, is finding a plan that will fit on this reduced size, because what we did is when we looked at the design of this layout, we were trying to get as close as we could to maximize the size on lots 1AR and 2AR, you know, to what was requested in terms of the square footage of those lots. So we moved those over, but we would not intend to move lot 3AR further to the east, because that would, I think what we have remaining there is, Kyle, do you remember the opening? I think there's 80 feet or something there.
Yeah, it looks like,
79, I think.
79, yeah.
I thought it was 93. Okay.
So
Okay.
our intent is we would need that opening to accommodate a structure.
Okay, well, I agree with everything Curtis said. I don't mind so much the setbacks because the properties are already developed right there. I'm just trying to figure out if there's a way to accommodate 3AR without causing so many adjustments to the two smaller lots. So that was my thoughts, but, okay, thank you.
Rachel?
A question for staff. If we approve this, you know, with staff stipulations, when the developers come in and they want to redevelop, you know, put the duplex in there or whatever they plan to do, are they going to have to come back and talk to us about this, or is it just a done deal? Do you understand my question?
No, it is not.
So Rachel, if I understood you correctly, you're saying that when they go to pull the building permit to put the structures on, will they have to come back and speak to Planning Commission? No, so the zoning would support the use. If they get the variance to the setbacks, then it would just be a building permit.
Okay, thank you. I struggle with this one because I know on the one hand, you know, what Kurt's saying is true. This is, you know, kind of dense. On the other hand, I know this neighborhood. Yeah, I grew up in this neighborhood. It is dense. You know, it's you have huge lots and then you have teeny tiny lots. That's just the way this neighborhood is. I also know that sometimes zoning actually gets in the way of affordable housing. That by being strict, you know, with existing structures, we make it harder for developers to actually develop homes that people can afford. And while we have no guarantees that, you know, when the developers sell these properties, that they will be affordable, we have no real way to guarantee that. It's hard for me to stand by and say, well, I'm going to say no to this on the basis that it's going to be dense, even though it's already dense. You know, so that's kind of what I'm struggling with right now.
I also have a light up from planning staff. Vicki, is that you?
Yes, thank you, Mr. Chair. So we've had some things change in this meeting today that we did not look at as we brought this recommendation forward. Basically, if we could show those three structures still X'd out, thank you. Removing those three structures definitely changes the situation and what we would bring forward as a recommendation. When we talked about it at our review team meeting, the fire department was very concerned that with all of the structural development on the site and all the numerous setback reductions that were being requested, that as a minimum, of course, we would want any new residential structure to be fire suppressed, but that even the existing ones do. With the removal of those three structures, and we would prefer to also see the shed on lot 2 or 1AR be removed, or they need to move that lot line farther to the east to meet the lot size requirement for that single-family home. So that's something that I think Karen would kind of meet some of your comments today, too. The 9,886 square foot for a duplex lot is significantly larger than what we would require. So it would take a pretty big footprint, even with the existing garage that would remain on the southern portion, to exceed the 30% lot coverage. That's something they would have to meet or seek another variance. So I don't think that would be an issue down the road. We would be open to removing the requirement that the existing single-family homes have fire suppression systems if we could, at a minimum, get the minimum lot size for the single-family home with that existing shed remaining in the front yard. And if it is your intent to approve this with the provision that the 3 structures be removed as on lot 3AR as proposed by the applicant, and if lot 1AR, that the variance to reduce that lot size be denied because they could move that lot line over. We also then need to clarify that the other variances that were requested for those structures that are going away would have to be eliminated from this, and we could kind of work through that once we get to that part of any motions that are being made.
I'm going to need a little clarity, and I might ask you, Kevin, to help me with this. When I heard you say that you're proposing to remove those 3 structures, it was something that you were intending to do after seeing if we approved the rezoning today, correct?
That's correct. I need to know if I have a viable lot to build on. So that was part of looking at, what is my overall building envelope, and can I fit a structure on there that'll support 2 living units? So that's what I meant to clarify that comment. Where I'm going is to, if I understand, we've worked through this, and staff has supported the proposal we put forth today, then I'll move ahead with my design, and if I've got a viable building there, then I would move forward with tearing those structures down. If I don't, we'll subdivide it, and I'll have to figure out what I'm doing with that lot. I'll have an open lot there that I've got to figure out if I've got an economic use for. And I've got to renegotiate with my seller,
So that leaves us in kind of a sticky position where without a commitment to remove those structures, I'm not sure there'd be an appetite or a recommendation, at least from staff, to remove the stipulation to sprinkle the existing residential structures.
That's correct, and maybe at this point it makes sense, if it's within your timeline, that we continue this to your next meeting, let the applicant make some final decisions, and then remove those variances that would no longer be needed, and then we'd have Mr. Billings at that time look at what the site plan would look like with any removal of those structures to see if he could support amending that stipulation. I just don't know that we can negotiate all of that in this meeting today.
I have a couple other comments up from the commission. Mr. Andreessen, would you like to comment to that right now, or let the other
I
folks
believe,
speak?
I'm willing to commit to tear those down. I have a viable building pad as proposed. If we're proposing, though, the comments to move it further to the east, I have to relook at that.
Okay.
But as proposed, I would be willing to commit in this meeting to pull those 3 structures down.
Okay.
In trying to get the removal of the fire sprinkler stipulation on the existing structures.
Mr. Chair?
Yeah, Vicki.
So Ken and I have been visiting a little bit. I think the concern is having that other accessory structure in the front yard with that reduced setback, side yard setback. So if there is an issue with moving that lot line further east, then maybe the answer would be take that structure down too, and that would clear up all of the front yard, and then the separation between structures becomes a non-issue, and that really does open up the discussion as to whether or not the existing residential structures would need to be fire suppressed.
Okay, I know we're doing a lot of back and forth up here, but how does that strike you, Kevin? And I assume we're talking about the structure on 1AR in the northeast corner. Okay.
I mean, it serves as an existing carport for that tenant that lives in the corner house today, but that's something I would consider doing. I obviously wouldn't have probably space to reconstruct anything for them to park under, but I can do that.
Okay. More lights now. I'll shoot it over to Kurt again.
I think Vicki answered my question, but I just want to make sure. Okay, we got that. I guess if you're looking at the X's up there, the second X from the left, that one that's on the right next to the other building that's might be tore down, and we have a 1.7 foot setback there right now. So if they tear that down, that setback goes to the normal required setback. So that 1.7 doesn't go forever, right? It just goes as long as that building is there.
Mr. Chair?
Yeah, Vicki.
So the variance requests today are to reduce the setbacks for the existing residential structure and accessory structures. So if the accessory structures go away, that variance request would be eliminated from the request today. The one for the primary structure will still be something you'll need to act on.
Okay, and what is the side yard setback requirement?
In this case, it would be 8 feet.
8 feet, okay. So you said you had a footprint that worked, and does that meet all the setbacks then?
It will fit on
It'd have
that.
the 8 foot?
It'll fit on that 80-foot opening, yes.
Okay. All right, that's all I had.
Vince?
Thank you, Mr. Chair. Yes, Vicki and Ken kind of answered that or addressed that issue. I had a concern with the fire suppression system, because of the density of this neighborhood and the reasoning why it wasn't affordable or economical for you. But yes, what's currently on the floor right now, yeah, it does make a difference for me with the removal of that carport. So you kind of answered that. Kurt kind of cleared it up for me too. So I really don't have anything else. Thank you.
I guess I'll follow up just to make sure it's clear in my head. If we added the stipulation to remove these 4 structures that have an X on them, Lot 1AR would still require some off-street parking. Does it exist on the west side, or would you need to add at a minimum some sort of a pad or a driveway to the north?
I would basically propose tearing that down. I mean, the driveway of that house comes in from Twin Elms, as he's diagramming right there. So that's the primary parking. There's only a single tenant that's currently in there. So if we tore that down, we may have to look at, I mean, there's 2 stalls basically in that driveway
Okay.
to accommodate that house. So I think it's sufficient for the size of the home.
Okay. And in general, the rezoning that we're, or not rezoning, the replatting that we're talking about doesn't absolve any of these properties from the parking requirements that exist.
Mr. Chair, you're correct. When they come in for their building permits to renovate the existing structures or build a new one, on their site plan, they need to show 2 off-street parkings for each residential unit.
Okay. Well, we've gotten a lot of far afield, but are we at a point where there's more questions, or if not, I'd look for a motion on this item. Vince, do you have
Thank you, Mr. Chair. Vicki said something earlier, and we did go over quite a lot. Would it be smarter just to go ahead and a motion to continue this to the next meeting so that staff can have more time to reevaluate everything that we just discussed? So, motion to move this to the next meeting so that staff can have more time to review.
Okay. Vince made the motion to continue item number 3 to the next meeting. What date is that? I don't know the date. Yeah.
February 7th.
February 7th. And Mike Kwasny seconded that motion. Is there further discussion on the motion? Seeing none, all those in favor, please say aye.
Aye.
Opposed? Aye. Motion carried with 1 nay.
Mr. Chair,
Yeah, Vicki.
we'll work with the applicant to ensure that we've got a revised site plan and that we update our report eliminating any variance requests that would go away. And that will give us an opportunity to visit back with the fire department on the stipulation requiring fire suppression on the existing residences, since the applicant has offered to remove so many of those accessory structures. So thank you.
All right, that's the last item on the Zoning Board of Adjustment. Is there,
Move to adjourn.
perfect. Karen made the motion to adjourn, and Rachel seconded that motion. All those in favor, please say aye.
Aye.
Aye. Okay, now we're going to commence the Rapid City Planning Commission meeting for January 24th, 2019. Again, if anybody wishes to speak to one of these items, please fill out a speaker request form and hand it to the staff along the west wall. Fill out the request with the agenda item of the number you wish to speak to and hand it to the staff. Consent calendar. Items 1 through 6 have been placed on the consent calendar and may be approved as a group. Action will be taken on all consent items in accordance with staff's recommendation by a single vote. Any item may be removed from the consent calendar by any planning commissioner, staff member, or audience member at this time. The findings of this planning commission are recommendations to the city council. The city council will make the final decision. Are there any items 1 through 6 that staff would like removed? Are there any items 1 through 6 that the planning commission would like removed? And are there any items 2 through 6 that any audience member would like removed? I would look for a motion then to approve the consent calendar items 2 through 6 in accordance with staff's recommendation. Karen made the motion and Eric seconded the motion, or Vince seconded, I couldn't hear. All those in favor, please say aye. Aye. Opposed? Motion carries. Item number 1, Kurt?
I'm listed as both present and absent at the last meeting, and I couldn't have been both, so if you could take me off of the, I wasn't here, so I was absent. So.
Yeah.
All right. So Kurt, would you make a motion to approve the planning commission minutes once you're taken off on the present list? All right, is there a second?
Second.
Rachel seconded that. All those in favor, please say aye.
Aye.
Aye. Opposed? Motion carries. Item number 7.
Thank you, Mr. Chair. Item number 7 is an amendment to our zoning ordinance to clarify the criteria and procedure for granting variances. In July of last year, there was a joint work session, and I think some of you attended. The initial topic for the session was to review the criteria and justifications for exceptions that are sought from the Infrastructure Design Criteria Manual. And it was at that meeting that the discussion turned to variances and the criteria that we use in the zoning ordinance. And there were some points of fact that they requested we look at for purposes of clarification. One of the complaints that we get is currently the ordinance requires that you submit a building permit before you can submit a variance. And in many instances, someone knows what they're short and what they need their variance for, and they want to be able to just walk in and make that submittal. So we are recommending that the requirement to submit a building permit and have it denied before seeking a variance be struck from the ordinance. And then currently, it states that you cannot secure a building permit for 7 days after a variance is granted, and there's really no purpose for that. Your decision is appealable in a circuit court of law, and they've got 30 days to appeal that, so there's no link with that timeline. And this way, if someone is granted a variance today, they could leave here, go straight to the building inspection counter and obtain their building permit or submit for it. Then we wanted to look at some of the language of the ordinance. It references an unnecessary hardship, which is difficult to explain. An unreasonable hardship is one that we see throughout the laws continually, and in addition to changing unnecessary hardship with unreasonable hardship, within the document itself, there's criteria listed as to what unreasonable hardship would mean, so that we can point to that specifically when we're bringing these forward to you. There are also special conditions attached to the property that may not apply to other properties in that district. The one we had this morning is one that is unique. And we've also set up some criteria for what those special conditions might mean. Our hope is that in clarifying this, we make it easier for the applicants when they are seeking the variance and trying to secure a building permit. In addition, to kind of beef up the language so that when we are making the recommendations to you and you're citing them back as a reason for granting or denying a variance, it gives us that legal justification that we need whenever we feel that opposition. Maybe the applicant doesn't like the decision or a neighbor doesn't like the decision. So this is really just a house cleaning item, but we feel that it'll be beneficial in the future as we review variances.
All right, thank you. Any questions on these proposed changes from the commission? I couldn't come up with any, and if Karen can't, I
Not this one.
must be done pretty well.
I'll move approval. Oh, sorry.
All right, Kurt made the motion to approve these, the ordinance amendment number 7. Is there a second? All right, Vince seconded. Any discussion? All those in favor, please say aye. Aye. Opposed? Motion carries. Item number 8.
Morning. Item number 8 is an ordinance amendment to revise the screening requirements between commercial zoning districts and residential districts. This is one that staff's had to deal with a lot. Again, it's more of a house cleaning item, housekeeping item, but there's a requirement in all commercial districts that a privacy fence be provided, screening fence between commercial districts and residential districts. What we have in that is language that says when in a commercial district is adjacent to a residential district. Now, if you go to the definitions in the Rapid City Municipal Code, adjacent includes public right-of-way. So we were having to grant variances to waive the requirement to provide a fence in the front yard setback, which didn't meet the height requirement, which is 4 feet, because it has to be a 5-foot to 6-foot fence. And then we're putting it in a front yard when the residential use is across the street or across an alley. So this would remove that issue. We changed it to abutting a residential district, which has to touch the property line, cannot share right away. So it started with that, and then we got into some language about, do we really want chain link fences with slats as a screening fence between a residential district? Maybe for screening in a storage area in a commercial district, slats, chain link and slats is okay, but when it's abutting a residential district, there should probably be that physical barrier of a solid fence rather than chain link with slats. So that was added. And then another issue we have is when a screening fence is required along property line, side lot line, or rear lot line, and there are either utilities or drainage or floodplain or any number of issues where we don't want the fence in that area. We do have a process called the zoning exception, which gives the director the authority to move the fence. So if the property line is lower than where the building is going to be, it makes more sense to have the fence higher on the property where it makes sense rather than along the property line. This just spells out that the director does have that authority where it didn't say that before. So cleaning up a lot of the issues that we have as staff have seen, and we know we've seen a few variance requests before the Planning Commission and Zoning Board for waiving that fence requirement. So that's what this ordinance is, and we're recommending to approve, and if you have any questions, let me know.
Thank you, Fletcher. Karen?
Thank you. I do have some questions. I think it's because I'm not understanding exactly in the ordinance when it's talking about only a 4-foot-high fence may be located in a front yard or side yard abutting a street. Well, if you're talking about properties that are abutting each other, that doesn't, and you mentioned it doesn't count the right-of-way. So how does that work? I mean, if it's abutting, or if you're saying it's adjacent to the
That would be
street.
if it's a corner lot, and so it has a side lot line that is adjacent to a residential district, which would require a 5 to 6 foot tall fence. But because it's a side lot for this property, if it's a corner lot, that would be the side lot that abuts a street. So we wouldn't want a 6-foot fence all the way to the property line when it abuts a street. So that's where it would, we're thinking primarily corner lots on this one, where there are 2 frontages. One of them would be a front yard, and one of them would be a side yard that abuts a street.
Okay, so in all these cases, then, I guess for me, it just sounds confusing because you're talking about adjacent and abutting properties. So if you have a property that's abutting a residential property that's abutting a commercial property, say, those 2 things, but it's a corner lot, then the side that's on the corner that's abutting the street, why would it even need one?
Let me see if I can do an example here. So this would be a corner lot.
Right.
Frontage here. That would be their rear lot line, but also the side yard, and this is residential. In this area here, that's the front yard that abuts a street. Or that's the side yard that abuts a street. It's their rear yard, but it's also in this area of 25 feet would be in the side yard that abuts the street. So this setback. Does that make sense?
So tell me, where would you put the fence? The one that's north and south, that's the one that would be the residential and the commercial. So that would require
Fence would be required along this property line, but it could only be 4 feet in the front yard that abuts the street, or the side yard that abuts the street, and then it would be 5 to 6 feet after that.
Oh, okay.
And then it's same on this one. It would have to be 4 feet in the front yard, and then 5 to 6 feet along the backside there.
Okay, now I see what you're saying.
And then the other intent is, since there's a driveway here, if the fence along this front yard encroached into the site triangle for that driveway, we'd be able to remove that requirement to provide the fence without them having to go through a variance.
Okay. Now looking at the picture, I understand it, but from the language, it didn't make sense to me. So I don't know if there's a way to clarify that better, but as an average person walking in, reading that, are they going to know without a picture? That's,
Mr. Chair?
Yeah, Vicki?
So our attorney's office has looked at this to ensure that that language does spell out the facts. When it is a commercial development and that screening fence is required, those are building permits that we look at every time, and we work with them to ensure that they understand what's needed. And in many instances, they have been trying to come in and always put that 6-foot fence, and then we've got the other part of the ordinance that says you can't have a 6-foot fence in a front yard. So in one place, we're telling them you have to put 6 foot, and in another place, we're saying you can't, and this kind of marries the 2 together. I think that because we have that hands-on conversation with commercial building permits, that based on the attorneys reviewing the language as proposed, I think we can get through it.
Okay, so once they come in for that building permit, they'll be able to understand it. Just reading it maybe beforehand, they won't, but they'll get the information eventually. All right, thank you.
Kurt, did you have anything? All right, good deal. Any other questions, comments on this ordinance amendment? Look for a motion then.
I'll move approval.
All right. Karen made the motion to approve item number 8, and Rachel seconded that motion. Any discussion? All those in favor, please say aye. Aye. Opposed? Motion carries. Any discussion items, staff items today? Kim?
Yes, I'd like to thank those of you who attended our work session last week on the TIF policy. I think we made some good headway there. We are preparing to have that ordinance come forward to you soon, hopefully by the end of February. And also wanted to mention we do have our next Coffee with Planners event coming up on Wednesday, February the 6th in this room, 9 o'clock in the morning. We are going to continue with the successful format we've had over the last couple of events, which is having 3 different discussion topics or discussion tables where each discussion will last about 15 to 20 minutes, and then those who are here can rotate to the other discussions as well. So what we've got lined up for this coming event would be a review of the Civic Center arena, the new arena, what the current design plans are, and some of the issues that we're currently dealing with on those. So Craig Baltzer, the Civic Center director, will be here to lead that discussion. We will also be reviewing the TIF policy. It'll be basically TIF 101 for those who are not really familiar with tax increment financing and how that works. So we will be doing a review on that. And then the other will be reviewing our office commercial zone and looking at the residential uses that are currently permitted in that zone and whether or not we should remove those. So those will be the 3 discussion items. As always, we've got free coffee and donuts and bagels, so hopefully you'll be able to come or at least pass the word on. Thank you.
So 9 o'clock, February 6th. All right. Any other items from the commissioners today? Look for a motion to adjourn then. All right. Mike Gallagher made the motion to adjourn, and Mike Kwasny seconded it. All those in favor, please say aye. Aye. Opposed? Motion carries. We are adjourned.